In June 2007, my husband Jeff and I started negotiations to purchase a piece of property. Since the property contained an abandoned, dilapidated house that would need to be demolished and removed, costs of which would be around $20,000, we set a firm and non-negotiable offer that we were willing to pay, and it was accepted. On June 7th, we wrote a check for $10,000 to Coastal Escrow for the initial deposit. Our check cleared. On August 7th, in preparation of the closing, we wrote an additional check for $20,000 to Coastal Escrow for the final deposit. Our check cleared. Coastal Escrow Services now had $30,000 of our money to hold safely for our August 31st closing. On August 29th, Coastal Escrow issued a $30,000 check to the closing agent. On Friday, August 31st, the beginning of the Labor Day weekend, prior to Coastal Escrow closing on Monday, we closed on the property, and all of the funds were dispersed to the seller, real estate agents, and miscellaneous payouts. When the newspaper articles started appearing the day after Labor Day about the Coastal Escrow Services, the closing agent checked with their bank to see if the $30,000 check had cleared. It had not, and was in the process of being returned for insufficient funds. When the closing agent learned about this, since they could not undo the transactions that had taken place on Friday, they had to deposit $30,000 of their funds to cover the outstanding balance due on closing. On September 11th, as a result of the $30,000 Coastal Escrow non-sufficient fund check, we were notified by the closing agent that they were demanding that we make good on this check, and if not paid by September 12th, they would have no alternative but to file suit against us. We were forced to hire an attorney to defend our very innocent position in an effort to protect our interests. In late October, the closing agent officially filed suit against us, partial terms of which would impose a lien on our property until settled. 8 months later, after spending almost $5,000 in legal fees, which I know is not supposed to mean anything here, but does, and agreeing to a $14,000 settlement, we were dismissed from the litigation and the lien that was placed on our property. Mr. Hatch, we did not know you personally, but your actions by allowing a $30,000 check that you knew was not good to be issued so that our closing would go forward on the very weekend you know you were closing your business turned our lives upside down. You set up this facade and led people to believe they could trust you with other people's hard-earned money, to put us through countless hours of worrying and sleepless nights as we tried to figure out how we could possibly be responsible for an additional $30,000 that we already paid. In the end, through our eyes and our savings account, you've taken $19,000 from us. To date, 3 years later, we've not been able to clear our land and move ahead with our plans for our property. You took the money we were going to use that. You obviously have no scruples. Quite obviously, you have no remorse. To hear you say in court several weeks ago that you were taking the plea agreement because it was in your best interest and not admitting guilt and responsibility is not only arrogant, it's a sin. I'll leave that sin between you and God. Judge Medelis, my husband Jeff and I are asking that you please hold this man accountable for his actions by giving him the maximum sentence of 30 years. What he did to us alone, if it stood all by itself, was a first-degree felony, punishable to a minimum sentence of 3 years, maximum 30. Consider what he's done to us alone and combine it with what he's done to hundreds of others, and he deserves no less. Please help us try to make peace with this awful situation his actions placed on all of us by giving him the maximum sentence. Please, don't allow us to become victims